So, Lucy, every time you and I tend to speak, it's about a supermarket of some description. We've had Aldi and M&S where we've spoken previously. This time, it's Tesco and Lidl. What exactly has happened in this case?
So, in this case, Lidl have accused Tesco of infringing its trademarks, and it's all about Lidl's trademarks. They've got some with words in them, but the ones that they tried to rely upon were the wordless mark, where it's a blue square with a yellow circle. And Tesco have used they've got a blue square with a yellow circle and the words inside club card prices. So that's the guts of Lidl's claim that Tesco's are infringing. And what Tesco have counterclaimed is that actually the trademark that Lidl have relied upon is actually invalid and subject to cancellation, as it was applied for in bad faith. And Tesco are accusing Lidl of adopting an evergreening strategy.
You mentioned bad faith and an evergreening strategy. I mean, let's start off with evergreening. What's that?
So evergreening is a strategy that some trademark owners employ, where they register a mark that's identical to an existing mark, often broadly for similar goods or services, before the existing mark's grace period has expired. So with trademarks, when you apply for a mark, you have 5 years to use that actual mark. And if you don't use it, then that mark then becomes vulnerable to cancellation proceedings. Because obviously, we don't want the trademark registry to be cluttered with marks that aren't actually used, because a trademark gives the owner a monopoly. And in this particular case, what Lidl had done is they had reapplied for marks with very similar specifications and not used that mark. And Tesco accused Lidl of evergreening.
And you also mentioned bad faith as well. What's the implication of that?
Well, if you apply for a mark, you're meant to have a bona fide intention to use the mark. And if you're effectively adopting this evergreening strategy where you don't have an intention to use the mark, then that's where the whole sort of bad faith argument kicks in. In these types of cases, there is a presumption of acting in good faith, and then the burden falls upon the party that's seeking the cancellation, so Tesco here, to prove otherwise, so that there has been bad faith, and that this whole strategy was intended to circumvent the whole sort of 5-year rule about using the trademark within 5 years and trying to gain a commercial advantage by doing so, so effectively abusing the trademark system. And
so this may ring alarm bells for businesses who've got an entire IP portfolio. In fact, I can think of people who bought lots of .coms at the time when the internet sort of first came about, speculatively, just in case. So it may ring alarm bells for people with an IP portfolio. I mean, how can you help those sorts of people protect those portfolios?
So, I mean, a really good point to raise here is that if someone is enforcing a mark against you, then what this case shows, first of all, is that bad faith might be, a good argument to run. It's always fact, sensitive and dependent, but this is a precedent that parties can rely upon. What I would say to companies that actually already have, a brand portfolio in place is that, it's worth having a look at your portfolio to see whether or not, based upon this decision, whether or not that some of your marks are potentially vulnerable to cancellation proceedings, and just looking at what your trademark strategy is to make sure that you have maximum protection in place. And, if you do want to rely upon your trademark to try and enforce it against another company, like what Lidl did here against Tesco, let's assess, first of all, how strong those brands are, because, it would be unfortunate to find that the right that you rely upon ends up actually being taken away from you.
I'm Dominic Walker, JMW's Inside Man.